Blood test.
Blood test.
Blood
Okay.
test.
Okay,
Oh
so
my
blood
God.
test. Okay.
Are we talking about voluntary?
There we go.
Okay.
Blood test. So the SCOTUS, or the Supreme Court of the United States, ruled 8-1 to reject. It was the Obama administration and several or a dozen or so states on a case where a fellow was speeding in some kind of Ford 150 or something.
Big truck.
Big truck or something like that, I believe. And he got pulled over, and he refused to
Submit to a blood alcohol test?
wouldn't take a breath test.
A DUI.
So he's, suspected of DUI.
So they strapped him down.
So they took him to a hospital and did a forcible blood draw. And they found out he was twice the legal limit. It was a .08, it was a .16, so he had a couple beers. And, the defense argued, well, there's no warrant for this. Now, up till now, in general, if the cops want to give you a blood test,
They can do it by force.
they can force you. And I know you've heard some stories about that.
I've had a lot of stories about that.
And also whether you're cooperating or refusing or not cooperating with a breath test, it's pretty subjective for the cops. I mean, if you blow into something, the cop goes, "You're not blowing hard enough."
Yeah.
Well, then they can force you to take a blood test because, the breathalyzer is a reasonably followable instrument.
Well, do you realize in the state of California, technically you can refuse all tests? But what's happened is, and this is why across the country people have been arguing this for so long, because most states say you can refuse the test. California can refuse the test.
But then
the
they'll take it
police
later.
don't want it. But the police don't want to let you refuse the test. That's the issue, because they're going to lose the evidence in 12 hours. So if they don't take that blood right now, they're going to lose their evidence they will support their case for the probable cause to pull you over, because then you weren't drunk because we never got a blood test. And at best you lose your license for a year, but you don't get a DUI.
Is it really that hard to get a warrant? Can't you just get a phone call and get a warrant?
No.
No?
There's not going to do that for every DUI that happens at 2 in the morning.
Okay, so what happened?
They don't have an automatic warrant issue.
They're going to get that magistrate who went into the
Yeah.
Boston hotel
Especially if
room.
you're in Boston, there's going to be a magistrate right
Okay,
there.
so what happens when you have a drink? Let's say you have a drink, and that's basically a 0.02% BAC, blood alcohol content. So let's say you have a beer, whatever you have, and so that's about a 0.02. Now your body, if your liver's working fairly well, eliminates about a 0.015% to a 0.02% per hour. So what the cops might argue is, like, every hour you're losing a beer in your bloodstream. So what they're saying is extension circumstances. Now what
Exigent.
Exigent circumstance. What Ruth Ginsburg argued was that in a case where the cops were after a guy. He pulls into his driveway, runs into his house and locks the door. Cops come and break down the door, right? And then they take him and they do a blood test on him. And the guy said, well, what, do you have a warrant to break down the door? Well, Ruth Ginsburg said, well, driving a vehicle while you've been drinking alcohol is like detonating an atomic bomb. That's how bad it is,
That was before Mothers Against Drunk Driving.
Yeah, so that was
Probably.
but that was the line of reasoning on that one, where you can break down the door, you can take the blood, but this is a big reversal of that.
Right. So my question for you, Mark, which I didn't get an answer to, is what was actually so outrageous about this case that they reversed? Because I didn't understand.
No, because this is what and I haven't studied this case thoroughly. I haven't read any decision on it, but from the take of the various media outlets, it's all about the fact that it's going back to the Constitution. And the Constitution says you're not supposed to be able to have your rights taken, especially self-incrimination.
Without a warrant.
Giving a blood test is a self-incriminating act, and that you're doing it by force, which means if I were to tie Mark down, flip the board up, and start pouring water down and saying, Mark, have you been drinking? You would, technically that wouldn't be allowed. But they're saying the invasion of your body with a blood test is similar.
No, you're absolutely wrong. Okay, you're completely wrong, Jim. Okay, it's got
Jane, you ignorant slut.
That's
what I thought you were going to say.
It has absolutely nothing to do with the Fifth Amendment or the right against self-incrimination. No, it's a fourth. It's a Fourth Amendment unreasonable search and seizure issue.
Well, yes, I agree with that.
Okay,
but
I hope
just
so.
that.
Because
Okay, so how did Scalia vote on this?
Oh,
I mean,
I don't know.
strict-
Mark, why don't you tell me?
I don't know. I don't know who
strict?
the one. I don't know who the one against, but
It was 5.
One said he was
8 to 1. 8 to 1. But
8 to 1. That means you got the whole panel.
Sotomayor wrote the majority opinion. So I mean, that's pretty.
Well, they have to give her something. She was appointed by the president.
So I mean, that's what they said here is that.
So.
But she went back to the totality of circumstances, right? And they're saying just how huge of a deal is this that you've got to take this, that this guy's alcohol is dissipating, that you got to invade his body. Now, and what they said, the compelled intrusion into the human body, that violates privacy interests. So I think what you had, the conservatives were kind of saying, well, look, this police power is kind of run amok, so kind of the conservatives are for it.
Wait a minute,
and then you have the liberals who are, like the privacy because they like that huge privacy.
Well, then I'm going to ask the question. Is this a liberal or a conservative ruling?
That was my question.
Yeah, that's a question. I mean, where are we on this?
I think it's a reason.
thought it was a surprisingly liberal ruling protecting drunkards.
You're completely wrong. You're absolutely
Well, wait a
wrong,
minute.
Dan. It's a conservative ruling because it's in favor of the Constitution, and liberals like to write the Constitution new every day with like a
it's a living
chalkboard.
document.
With a chalkboard. I mean, the liberals it's a chalkboard Constitution. It's not like it's like I promise to pay you $10 a week, but no, I'm going to pay you $1 a week because
Hey, what can you say?
It's a living contract.
It's a living contract.
It's a living debt. It's living mortgage.
It's a living debt. But you know what? What's interesting, Mark, is that through all the period of the modern criminal justice system, and as you know, I have both a master's and a bachelor's in criminal justice prior to anything else I've done. I'm going to tell you something. This is actually a liberal view, and because although
you're absolutely right. He's wrong, but you're right.
The reason I say that is
because
the original liberal the concept in criminal justice was rehabilitation. But rehabilitation went along with protecting the rights of each of the criminals along the way.
So they
and
don't
that
feel...
was a liberal view. It wasn't a conservative view. The conservative view was
law and order.
Law and order, law and order, law and order. But no, we're not doing that. We're talking about protecting the rights so there's less law and order, which makes it a liberal point of view. And it's interesting to have the 8 to 1 because now you're saying, what is this? It's like they're all, what is it really? Is it liberal or is it conservative? Is it really, is the Constitution conservative or the Constitution is supposed to protect us all? This is my premise. The Constitution is to protect us all, and it should be interpreted by both sides of any aisle. And it is a liberal document to protect us. It is a conservative document to protect us. But then how do you argue what position this decision was coming from? How do you argue that with any sense? I mean, this is why Dan and I, we look at each other and there's a little conflict.
No, but I think it's for different reasons. I think the liberals voted for it because it's a privacy issue, and there is nothing in the Constitution. There's nothing in the Bill of Rights that talks about privacy,
which is the living document concept.
Yeah, so that's like kind of a chalkboard kind of constitutional thing, and so the liberals love that because it's like, okay, we'll
recreate it.
We wrote because like. Oh, when these stupid guys, 200 years ago, I mean, like, just think of, let's think of the Roman Senate. That was 2000. They didn't know anything.
They didn't know anything.
They didn't know anything about that.
They only set up modern,
I mean, they didn't know anything. So that's like, and we just figured out everything in the last 20 minutes.
Oh, that's because it's a living document.
And
by the way, they didn't have cell phones then either.
So I would say the liberals like it because of privacy, and I think the conservatives like it because it's the Fourth Amendment.
Yeah, and you know what's interesting? That's a paradox. There's almost a paradox for that because
and that's why you got 8 to 1. That's why.
Yeah, and when you get to 8 to 1, you're talking about who's voting for this.
Everybody.
Everybody's voting for it.
Yeah.
In fact,
but anyway, listen. I notice our time's up tonight, but I will say that it's been another interesting show. And Dan, I got to tell you, you got to come back and be a guest with us because this is a lot of fun. It provides a different perspective, and I hope everything goes